Let's go on the record on cause number DC 2214722, Irvin versus Unlimited Towing Services. Counsel, make your appearances.
Christopher Sisk for the plaintiff, Angel Irvin.
Brad Dickens on behalf of the defendants, Sergio Sandoval and Unlimited Towing Service.
All right, let's proceed.
Thank you, Your Honor. Again, Brad Dickens on behalf of the defendants. Your Honor, this case, and I'm sure the court has had an opportunity to read the briefing, so I won't belabor the point, but this case arises out of a motor vehicle accident that occurred on December 11th, 2020. Mr. Sisk's client, the plaintiff, Angel Irvin, claims a number of personal injuries relating to that accident, but at issue before the court today is the injury to her right hip. The plaintiff contends that as a result of this motor vehicle accident, she injured her right hip, which necessitated a surgery. The surgery in question...
So I've read all the briefing on this, and I get your argument is that he never, your allegation, I guess, is that he never really states that the injury is called, in the accident based on reasonable probability caused the injuries, essentially, right?
Yes, Judge. And I guess just to be clear, what Dr. Kerr actually said in his deposition, and I know the court has read this briefing, so you can see the page and lines from his testimony. The issue is whether it's more likely than not, based upon a reasonable degree of medical probability, that the surgery, there's no question that the surgery was needed. The issue is whether it was needed as a result of that December 2020 accident or the fall that she had well after the accident in the shower. And so without that testimony from Dr. Kerr, again, where he's not able to, in all fairness, we're not challenging Dr. Kerr's qualifications. He's certainly qualified to perform these kind of surgeries. He's just not able to say, based upon a reasonable degree of medical probability, that this injury was specifically, or really that the condition of her hip that necessitated the surgery was caused by this motor vehicle accident. And so without that, we believe that this testimony is not only irrelevant, it's unduly prejudicial to my clients because a doctor of Dr. Kerr's esteem at the Carroll Clinic is going to testify, and the fact that he can't testify as to whether this injury was caused by this accident, I think unfairly prejudices my client, and it's also not, it does not meet the standard of Daubert and Robinson for those reasons.
All right, response?
Yes, Your Honor. I think there's a bit of putting the cart before the horse there. This is just a Daubert challenge to Dr. Kerr, and Dr. Kerr is actually very clear in his deposition that he says he can't say whether or not this annular tear was caused by the crash, but what he can say is that within a reasonable degree of medical probability, the annular tear could have occurred in the crash. It is equally probable that it could have occurred solely in the shower, or it could have been that there was it's reasonably probable that she suffered some other hip injury during the accident that was then weakened as she was relying more on her left leg as opposed to her right leg. That weakened the hip, and that caused her to fall when she was stepping out of the shower. So you have three distinct possibilities that all of them are could have led to this injury within a reasonable degree of medical probability. And Dr. Kerr walks us through in his deposition exactly how that is. And quite frankly, the defendant's expert agrees. During the defendant's own expert's own deposition, he agrees that this is the type of injury that Miss Irvin suffered during the car accident is one where, even if it's not the full annular tear, could have led to instability in the hip that caused the fall that then led to the annular tear that required the surgery.
So you cite to a number of cases in your briefing. One is the Wallace case. Another is the Baxter Healthcare Corporation case, both out of the Dallas Court of Appeals. Do you know the facts of those cases? What exactly happened in those cases?
Yes, Your Honor. Those are both medical malpractice cases where the defense argument, and I don't remember the facts off the top of my head, but the crux of it on both those cases is that the defendants were saying that, hey, they've got to show they've got to eliminate everything. They have to eliminate every possibility in order for this expert to be able to testify. And in both the Wallace case and the Baxter Healthcare Corporation case, the court said, well, hold on, they don't need to eliminate every single potential alternative cause of the injuries, of the medical negligence. They just have to show that within a reasonable degree of medical probability, this injury would have been caused by negligent act. And that's exactly what Dr. Kerr is doing here. He's not eliminating these alternative causes. He's saying that all of them are equally probable because he didn't have imaging from before the accident. So that's the province of the jury to determine the sufficiency of the evidence. But when we're talking about just the admissibility of the expert's testimony, we're just looking at, do they connect the dots? And Dr. Kerr does here.
Your Honor, brief response.
Yeah.
Your Honor, if Dr. Kerr was simply a fact witness here, I think the jury, I agree with Mr. Siss that I think the jury could decide the credibility of a fact witness or a lay witness testimony as far as here's what I saw, here's what I treated. The problem is Dr. Kerr has been designated as a non-retained expert. He is going to purportedly offer medical opinions, and he does not offer any opinions as to a reasonable degree of medical probability whether the condition of Angel Irvin's hip in fact, Your Honor, I'm reading from page and line from Dr. Kerr's deposition. Whether the condition of Angel Irvin's hip that you performed surgery on in May of 2022, whether that condition was caused by Angel Irvin getting out of the shower and feeling the tearing sensation that she described, or whether it was caused by the motor vehicle accident in December 2020, you do not know based upon a reasonable degree of medical probability. True? Answer. True, that I cannot say with certainty when it happened. And you cannot say whether the condition in her hip was caused by either of those events based upon a reasonable degree of medical probability, correct? Answer, no. And so, Your Honor, simply saying it could go either way or it's equally possible. And Your Honor, certainly this court is aware that is not the standard under a preponderance of the evidence or frankly under Daubert and Robinson for expert testimony. It cannot just be, it could go either way. The testimony is, the standard is it based upon a reasonable degree of medical probability? And he answered very clearly under oath, the answer to that is no. He cannot tell us that. And so the problem is, without that, Your Honor, I think the court has to exercise its gatekeeping function here and not allow Dr. Kerr to make opinions and conclusions that he has already told us under oath he cannot make.
And Your Honor, a brief response.
So I guess what I'm trying to get at it, and I don't think I'm being very clear about it, is are there any cases, specifically, preferably out of the Dallas Court of Appeals or the Texas Supreme Court, that talk about a situation like this where there's multiple potential causes, and the doctor, usually what you see in this situation is that there's multiple potential causes, but the doctor will say, based on reasonable medical probability, that he thinks that, usually it's the accident caused the injury, but there's other possible causes. This is kind of unusual because he says, well, based on reasonable medical probability, it could be this, or it could be this, or it could be this. Are there any cases? I guess I've been doing this a long time. I can't think of any cases that talk about that situation in the context of an accident. You do see some things like that in context of like a toxic exposure or pharmaceutical exposure, things like that, or asbestos or things like that. But what about an accident like this? What happens where? Does that make sense?
Yes, it does, Your Honor. And one point of clarification for the court, and I certainly understand the court's question here. I will, just to clarify though, Dr. Kerr actually does not even say, based upon a reasonable degree of medical probability, it could be this, this, and this. He does not even commit to a reasonable degree of probability. He just says, essentially, it could be this, this, and this. And I think that's an important distinction because he doesn't even commit to that standard for all of the possible scenarios here, being either the December 2020 motor vehicle accident or the fall of 2021 accident in the shower. So he doesn't even go that far. But Your Honor, to be candid, I'm not aware of any specific cases on this issue other than, certainly Robinson and its progeny on this issue.
Your Honor, I didn't see any within the accident context. The ones that we were able to come across for medical malpractice or toxic tort cases that do deal with alternative causations, in the court saying, you know what, you don't have to discount every single alternate cause. I'd also point your attention to pages 66 and 69 to 70 of Dr. Kerr's deposition, where he specifically states, there's a bunch of possible explanations for this, but I think that those three that we're discussing at the time, the accident itself, the fall itself, or a combination of the two, are probably the ones that we're dealing with at this time. And within a reasonable degree of medical probability, any one of those three could have been responsible for the hip pain. Yes. So what we're looking at here is we're looking, I guess, for case law that says that you have to be firm on one and you maybe don't have to discount the other, but you can't say that all three are equally probable within a reasonable degree of medical probability. And I've not come across any case law that says that that's disqualifying to a witness. Indeed, if you look at the toxic tort case law, if you look at the med mal case law, where they do discuss alternative causation, it's clear the court has allowed all of those alternative causes to go to the jury on the basis of the expert saying, yes, this is reasonable. It is reasonably probable that this led to the injury, and it's also reasonably probable that this alternative cause or this alternative cause led to the injury.
Mr. Dickens?
Your Honor, so Mr. Sisk read from page 66. The problem is, if you read further on, so starting on page 72, we asked him this same question. And we asked him whether, and in fact, Judge, we actually said whether this December 2020 motor vehicle accident exacerbated a condition in her hip. And we said, you cannot say whether that's the case based upon a reasonable degree of medical probability. And he said, I can't say whether that is the case. I can't definitively say that is the case. He said, in fact, he even said, I don't have any objective evidence to let me say that that is absolutely the case. We also asked whether the full thickness tear could have been caused by her getting out of the shower. And he says that could have caused it as well. And so again, Judge, it's one of those cases where depending on, whether it was cross-examination or redirect, he ultimately did not commit, while Mr. Sisk on redirect, got him to say, well, I think it could be all of these. Then on redirect, he says basically the opposite, which is, I can't say based upon a reasonable degree of medical probability. And so the problem is what we're left with is a doctor who has, certainly performed a surgery. There certainly was an annular tear in her hip, but he has no opinions based upon a reasonable degree of medical probability that one of these, whether it was more likely than not. And I think the distinction here between this and a toxic tort case is this page in line that I've noted here for the court about the exacerbation, because that's really how you would tie this to a toxic tort, right? Was a worker exposed to asbestos at factory A, B, C, and D, right? It could have been any of those factories over a 30-year period, right? That's typically how those asbestos cases go. Okay. The difference here is we asked him specifically about the exacerbation of a pre-existing condition. That's how you would even get to this type of analogy here, right? Is she's in the December 2020 MVA. Then she falls in the shower, but that December 2020 MVA the fall in the shower exacerbated the December 2020 accident. Dr. Kerr has told us under oath, he says, I can't say whether that's the case. I can't definitively say that that's the case. And he even says, I have no objective evidence to let me say that that is absolutely the case. And so the problem is, following the toxic tort analogy, he's basically just saying, here's two different events that happened, right? But I can't say, based upon a reasonable degree of medical probability, whether either of those caused it, right? He says those are events that happened, but he doesn't say based upon a reasonable degree. And I think that's key here.
And just one clarification there, when he's answering that he can't say it with certainty, that goes beyond reasonable degree of medical probability. That even goes beyond a reasonable doubt that you have to have in a criminal case. So he's really setting the bounds, because we're on direct. I'm asking him within a reasonable degree of medical probability. He's saying, yeah, it could be any one of these three within a reasonable degree. That's the lower bound. But he's not willing to go all the way and say, yes, it's absolutely caused it, which is what his responses were to Mr. Dickens and all the page lines cited in Mr. Dickens' testimony. I can't say that with absolute certainty. I can't be absolute and say that. I can't forget what the third one was. that Mr. Dickens just mentioned, but being able to go all the way and say that it's concrete, I don't have any objective evidence that this is the sole cause. Whereas before he has gone back and forth and said, look, it can be any one of these three within a reasonable degree of medical probability. So he has set the bounds himself. The requirement that he has to be 100% on which of these three caused it, I haven't seen any of those requirements in the case law. The alternative theories are still able to be pled and heard by the jury, especially where it's a witness who was only a treating physician. He wasn't an expert witness who was hired to go in and do a review or audit and look at deposition testimony. You're sitting at the trial and listen to the testimony of the parties.
And Your Honor, to be clear, I'm not suggesting that the standard here is absolute certainty. And in fact, I didn't even ask Dr. Kerr that. He offered that testimony on his own. But the key here is on page 72. I said, Dr. Kerr, you cannot say whether that is the case based upon a reasonable degree of medical probability, which is the standard. And his answer is, I can't say whether that is the case. Now, he goes on to say definitively in those things, but he does answer, I can't say whether that is I can't say whether that is the case. And that's page 70.
I will say that this doctor is all over the place. I mean, I used to do this kind of law, and I can see how frustrating this probably was for both of you, especially Mr. Sis, because it seems like what he's saying, that it's 51% likely it's A, it's 51% likely it's B, and it's 51% likely it's C. That's more than 100%. I mean, the attorneys aren't good at math, but I hope we can all understand that's over 150%. I don't know what to do with that. I mean, this is a new one to me, to be honest. I don't.
Your Honor, if that math added up to 100, I don't think Mr. Sisk and I would have bothered the court with this issue.
Yeah, no, it's. Maybe this doctor is not very good at math. I don't know, but that's essentially his testimony. I'm sure he's a very good doctor, but. You have any other doctor you could have testify about the surgery, or is he the only guy?
He's the only one who performed the surgery.
Did anyone else testify as the causation?
Not at this. Well, we got kind of close with the defense expert, but that's about it.
Well, have y'all been to mediation on this?
We have, Your Honor.
Did y'all get close?
We're close, but not close enough.
You know what I'm going to do? I'm going to take this under advisement and I have some interns starting soon. I'm going to let them do some you guys haven't found any case law. I'm going to see if they can find any case law that addresses this particular issue, because you got to think there's been other times when doctors have done this. And what do you do? I just haven't seen it. So we're going to do some research on this, and I would encourage you both to try to see if you can work this out. So we'll try to get you a decision at some point in the future. Okay.
Thank you, Your Honor.
Thank you, Judge.
All right. You guys have a great rest of your day. Okay.
You too.
Yeah, jury trial tomorrow,
Maybe
possibility.
we have well, let me check. It keeps changing. Hey, Eva, the Cornerstone case is still on the docket for tomorrow.
Yes, sir.
Can you close that?
Close what? The case?
Yeah, the case is settled. I've signed an agreed judgment, but it's still on the docket for tomorrow.
Yes, sir.
So go ahead and close it and take it off the docket, please.
Will do.
Our number one case is there's a pro se plaintiff, so that's what we have.
It is, but I have, I believe the ex-attorney may appear on it as well.
Oh, really? Okay.
Okay.
All right, are both sides here on the Thuman case?
Good afternoon, Judge. Did you mean Thurman?
Glenn, it says Thuman here. Is it Glenn Thuman versus Aspen GV?
I represent Glenn Thurman, Inc. And I think we're in a post-answer default situation. There was no response to the partial MSJ filed. And so I don't expect opposing counsel to appear.
All right, Tony, you ready?
I'm ready.
Let's go on the record on DC 2311872. Glenn said it's Thurman.
Yes, Judge.
Just so you know, in the system, it's listed as Glenn Thuman. I don't know if that's a clerk mistake, but Inc. versus Aspen GV LLC. Counsel, make your appearance.
Luke McMahon for Glenn Thurman, Inc., the movement.
All right, let's proceed.
Thanks, Judge. This is a construction case. It stems from a planned project to build a subdivision in Grand Prairie. My client, Glenn Thurman, gets hired to come in and do some of the paving infrastructure work associated with these types of developments. The LLC defendant, Aspen GV LLC, entered into a contract with my client in March of 23. We effectively did all the work, submitted a payment application pursuant to the contractual provisions dictating how that's done, and there was no payment ever made or received. In a series of conversations with the LLC defendants members since then, the story was essentially, we're having funding problems and we'll take care of you as soon as we can. And that started about a year ago when that, or about 11 months ago, when payment on that payment application became due. When I filed this lawsuit, an attorney did in fact file a general denial on behalf of the defendants. I've spoken with them on several occasions, even after the filing of this motion for summary judgment. Gentleman named Ronald Hines, he acknowledged the filing, talked to me about some current money troubles that his clients were having. And I told him about our Trust Fund Act claim as a way to encourage his clients to prioritize this case a little bit more seriously than perhaps some of their other financial issues that are going on. And that was the last conversation I had with the gentleman probably about a week and a half ago. As the court knows, liability is effectively proven up on a post-answer default. I have submitted a proposed order, which I believe got accepted by the court's ECF on February the 20th. It's a partial summary judgment we're seeking because we're asking the court for a judgment on the principal amount owed. We're also asking the court for a judgment on our declaratory judgment claim, which simply asks the court to declare that any further performance obligations we might have otherwise had under the contract are discharged. And we're also seeking partial summary judgment on our Prompt Payment Act claim, which is Chapter 28 in the Property Code, and effectively provides for a heightened accrual of interest in situations where in the owner general contractor sense, a payment is not made by within 35 days of the date that the invoice was properly submitted. And so in both the motion and in the proposed order, I break out how that prompt payment interest was calculated and have tabulated it for the court. And the claims that will remain before the court will be the Trust Fund Act claims against the individual defendants, which are the members of the defendant LLC.
Okay, the court will grant partial summary judgment as requested. We will go ahead and sign that, and you have a great rest of your day, okay?
Thank you, Judge.
Hello, Ms. Hawkins, how are you?
I'm good, Judge. How are you?
Good. Are you covering this hearing yourself, or do you have a,
I am covering this hearing myself.
look at you, wow. See. And did you put the other side on notice? I guess there is no real other side.
Yes, Your Honor, we do not know who the other side is as of yet, so no notice was given.
Okay, well, let's, Tony, this doesn't need to be on the record. Let's hear your argument.
Okay. First, hello, my name is Paige Hawkins. Again, I'm here on behalf of plaintiff AF Heshmanpour LLC. First, Amir, our client who owns AF Heshmanpour LLC, he founded not only the plaintiff as that company, as well as 11 other companies. He's kind of known in the community by his name and his reputation through these various different businesses. The defendants in this case are people that have made false, misleading, and defamatory statements about him and his business reputations, his methods and manners of doing business on this website that they created. The website's domain that they purchased is the plaintiff's name. It is amirheshmanpour.com. They're specifically using his name to not only just defame him and his, but as well as all his different businesses within the community. This is causing imminent harm to him because not only is this affecting his reputation, but it's also affecting the value that is associated with his own name. It's preventing him using his name if he needed to set up a domain name, as well as his current business reputations and those that come across this website, as well as any future business that he is going to need, or people that would be looking him up to potentially engage in his business. And now the TRO is our only adequate remedy at law, not only to enjoin the defendants from this conduct, but also so that we are able to contact and maybe gain information on the identity of these defendants through the third parties that are maintaining, hosting, and controlling the website. If we are able to subpoena those third parties with the court order signing this TRO, we would then be able to give them the authority to release the information of the specific individuals that purchased these domain names, provide their identity within this lawsuit, and specifically enjoin that behavior, as well as any other behavior putting up any other websites or defamatory websites and remarks and statements about the plaintiff.
So I thought it was kind of interesting how, I guess, why didn't you guys try to enjoin the hosting service for these websites?
So we're unable to enjoin them or to give them any sort of direction with this without a court order. They won't be able to comply with that specific request just coming from us.
I mean, but why didn't you sue them?
The hosting
Yeah,
website, I guess it really is the lack of knowing exactly who's behind this.
okay. I'm a little concerned. I'm not sure how this will all pan out, but I'll go ahead and grant it for now. have you looked at, is there any case law that talks about enjoining a John Doe?
Not specifically. I do know in previous cases, it was needed to get a TRO to contact like Google, who the John Doe defendants were using Google's platform to damage a client, and we weren't able to contact Google to prevent this and take it down without a TRO and a signed court order. And then once we did have that court order, they were able to do as we were requesting and prevent that.
Okay. All right. I will go ahead and grant this. We're gonna set the temporary. It says trial, I think a temporary injunction, not a trial. So I've set the bond at $100. I've set the temporary injunction on April 1st at 10:30 a.m.
April 1st at what time?
10:30 a.m.
Okay. Thank you, Judge.
And Gary, can you see if Marissa can come down here? You'll need to have somebody post the bond. I don't know if you're gonna do that or if somebody needs to post the bond on this.
Okay, we'll get that done.
Thank you. It's good to see you, Paige. Everything going
It's
okay?
good. Yes, going good.
I saw Sarah last week.
Oh, nice. Wait, which Sarah?
Sarah
The one at Texas Tech?
Heisenberger. How do you say her?
Okay.
Heimberger.
Yes,
Sarah
Heimberger.
Chig Heimberger. And with her boyfriend. So, and she's going to move to Richmond. So.
Oh, nice. Yeah.
I sent everyone a text. Does Sydney have a job lined up after she graduates?
She does not, but I can tell you she's relocating with a bunch of her family to Nashville.
Oh, okay.
So if you have contacts in Nashville, sure,
No,
she would help.
no. I have a pretty good job lead for a job here in Dallas, but I'm pretty sure everybody else has a job lined up. But do you know of anyone out of the group that doesn't?
No, I'm not sure.
Corey, what about
Anyone
Corey?
else? I'm sorry?
Corey Weston, what about her?
I can text her. I haven't seen anything specifically, and if she does, but I can text her.
Anyway. All righty. Well, good. Well, you have a great week. Are you in Dallas now or are you down in San Antonio?
No, I was there for a few days last week, just for spring break, but now I'm back at school.
Okay. All right. Well, it's great to see you. Keep in touch. You're taking the bar this in a few
July.
months, right? Are you going to take it in San
Yes.
Antonio or Dallas?
San Antonio.
Okay. Well,
Yeah.
well, come by and say bye. Say hi when you come back.
Of course. Yes. I owe you a dinner. Definitely.
Yeah, or at least a lunch.
Right. Okay. All right. It's good
I'll
seeing
talk-
you, Judge.
All right. Good to see you.